Hi, I'm Philip Hundl. I'm an attorney. My law practice here in Texas focuses on representing landowners in facing condemnation proceedings and also in land partitions. We've seen an uptick in land partitions, so I'm doing several videos on land partitions. So hopefully this will be helpful to those of you that are facing a partition matter, be it with your family or other non-family co-owners. And that's what I want to touch on today is in Texas, the land partitions have the applicable property code or law that applies to partitions is Chapter 23, and that's always been the chapter. And we'll talk about how the old statutes for land partitions, it was Chapter 23, and then recently. Several years ago, the legislature passed a Uniform Partition of Heirs Property Act, and that's called 23A. And so it's a whole different proceeding. I always say it's a partition plus. There's some additional steps when you're dealing with heirs property. And so let's talk about what is heirs property. Heirs property. And I always refer back to the statute just so that I'm not sure make sure I don't miss anything. First, there's no agreement on a record in a record binding on all co-tenants that governs the partition of the property. And I guess what does that mean? That means that there could be years before some agreement in either a deed or a will that says this is how this land is going to be divided. And if that's the case, then 23A doesn't apply. But let's just say there is no agreement, in a record. Then one or more of the co-tenants acquired the title, the interest that they own from a relative, whether living or deceased. So, one of the co-tenants receives it from a relative. And then any of the other factors apply, and this is where it's I always call it the 20% rule. 20% or more of the interests are held by co-tenants who are relatives. So think about if 20% of the property is owned by folks that are relatives, and it's interesting how it talks about sometimes you'll just think about, well, it's cousins or siblings, but a relative means an ascendant. We don't hear the word ascendant much, but ascendant meaning that would be between father, grandparent, or descendant, obviously someone's children, or collateral, or an individual otherwise related to another individual by blood, marriage, adoption, or law of this state other than this chapter. So sometimes that comes up. Well, the other co-tenant was adopted, so that doesn't really count, and it does count. So someone that's adopted for all intents and purposes in Texas under the law, that is a relative. So so keep that in mind. First step always when you're having to prepare a petition for partition is to determine whether it will fall under Chapter 23, non-heirs property, or under heirs property, Chapter 23A. Okay? So good luck. If you're filing a petition for partition, please remember to determine Chapter 23 or Chapter 23A. Is it heirs property or not heirs property? Good luck.